Good morning, everybody, and thank you all for making the effort to get here for the earlier start of 9:30. That's very helpful. Just a few things I'd like to mention at the start of today. Just remind us about some of the points that I mentioned in resuming the inquiry yesterday morning. I referred to a possible update in terms of suggested conditions were the appeals to be allowed. Would be helpful if I could have an update on that by early Monday morning next week, in time for it to prepare for the round table. And similarly, in terms of an agreed right, so that was the first point, just on conditions for the 4 appeals. Secondly,
Inspector, just the time for that, did you say that would be helpful to have by Monday evening?
Monday morning.
Monday morning?
Yeah.
Okay.
Early Monday morning. So I didn't want to be prescriptive and give a specific time, but in advance of noon, certainly. Then I'll be able to pick it up.
Because we're recommencing on Tuesday, aren't we? So
we are, yes.
Yeah.
Yeah, but I just want to see it beforehand.
Okay.
And similarly, in terms of timing, an agreed programme of site visits would be helpful by Monday morning next week. And then just a few things by the end of this week, by Friday morning, if possible. Firstly, I asked for a list of recipients of the inquiry notification.
Yeah, that's been sent through to PINS, Inspector. So if it's not made its way to you yet, that was
No.
sent through immediately yesterday morning.
Thank you. I'll note that. And if that could be uploaded to the website as well, that would be helpful. And then just going back to the basics of the proposals, I just wanted confirmation of descriptions of development for sites A and B, which I don't think had been finally agreed, and just a confirmation about, because of the confusion with the plans early on, I just wanted confirmation about the composite location plan. That I think was touched on Mr. Smythe's evidence. And finally, for the council, it was hopefully mentioned yesterday that we could leave documents during the week in this room. That the same would apply next week. I just wanted to, if you could check the position over the weekend, whether we can leave things out or whether we need to pack away and perhaps they can be stored here and brought out again on Tuesday morning. And I did have a point for Councillor Britton. I see he's not here this morning, but could a message be relayed to him, please? Yes. I presume he'll be talking to the updated information which the parish sent in. That's my expectation, rather than inviting him to participate isn't an invitation to go over the ground, as he's already mentioned. Yeah, thank you. That's all I want to say at this stage. Can I just check with the main parties whether there's anything they need to mention? Mr. Cottle.
Only that in the inquiry documents
yes.
Presented in November 2024,
yes,
there was a greater crested newt mitigation plan, which I'm going to be asking Mr. Sibbott about later today, ID 7.5. And I just looked at it and realised that the decision that it was attached to hadn't gone in. And really, for the sake of Mr. Sibbott, and perhaps out of curiosity for yourself, I have a copy of the decision.
But we'll give it context, I presume.
That's right.
Yes.
Points might be against it or favourable. I've got copies here. There's only one other item I wanted to raise, which is that the personal circumstances session tomorrow
yes.
has personal circumstances which are not on the website.
That's right.
And
yes.
I wanted to make sure that the WS planning documents that had been submitted to PINS were with you.
I can tell you what I've got. That would be helpful.
From the website.
Should I let you know what I have?
Well, I don't mind if we do it later on today.
But I can do it quickly now.
All right.
I don't want to forget it now you've mentioned it.
I'm just concerned because I have a plethora of documents in the High Court proceedings.
Yeah, let me just have a quick look. I should have them all together.
There was an independent social workers report, for example.
Right, the documents that aren't on the website, because they are sensitive, relate to sensitive information. Firstly, I've got a statement from Mr. Thomas Doherty
Mm-hmm.
in relation to A, and then attached to that are a series of letters concerning health circumstances. I've then got, in relation to your case, Mr. Cottle, a statement from Mr. Simon Doherty. And attached to that, again, a series of, in this case, not only letters concerning health conditions, but also a couple concerning education.
Is there an independent social workers report there?
Let me just quickly look. There's a letter from the Ridgeway School. I'll try and pick out the ones that want to do with health. I think there are two from. So that's a duplicate. So some of them are duplicated. But I have two from the Ridgeway School.
Can I just ask, Stephen, the independent social workers report, was that part of the court pack of documents, or was that separate from it? Do you recall?
It was in the bundle for the High Court.
Okay.
Right. I've been through what I have, Mr. Cottle. So
And it's not there.
It's not there. It's for the most part health documentation, and then two about the Ridgeway.
Well, there was also an independent social workers report obtained in relation to Mark and Alana, actually. And there was a dispute as them not being allowed to rely on them. And it went up to an appeal to the Court of Appeal, and Lord Justice Singh dealt with it. But so it was shared between the parties, the main parties. But
on a previous
it's
occasion.
not before you anyway.
Yeah, and I haven't seen that either. So, because obviously I wasn't instructed on those proceedings.
Well, I'll take instructions and just try and remedy that. Do excuse me for wanting to check.
No, that's fine. I just wanted to thought it's best to check now in terms of what I have. That's what was sent through. So, if it's something that you wish to rely on and seek to put in, please let us know soon.
Well, I've said I'm going to take instructions and
Yes.
discuss it with my learned friend.
Yeah, understood. Ms. Cottle, do you wish to put in the decision that you referred to? You have it, Mr. Lindsay.
I've got one copy. If you've got a spare for me as well,
Thank
that'd be
you.
helpful. Thanks, Steve. Now, obviously, Inspector, I've not read this yet. I mean, I appreciate Mr. Cottle saying it's for context, etc. But
Yes,
I just have to say that by way of
yes.
context.
Well, yeah, but bearing in mind it relates to a document that's already in.
Yeah.
It seems as though we really should have it. But yes, if you've got reservations, you'll let me know.
Yeah, well, it's so close to starting, but I will certainly read it at the first opportunity I have.
Yeah. Yeah. Right. In terms of numbering, I think we just had the one document yesterday, which was, so I think it'll be 18, unless you want to.
Yeah,
So
it would be 18.
Okay, thank you. Thank you, Mr. Masters. Have you got any points you wish to raise at the beginning? No, it's okay. Mr. Lintott, anything from the local authority?
Nothing for us. Thank you, Senator.
Okay. In that case, can we pick up with questions to Mr. Woods, please? Mr. Lintott.
Thank you, Inspector. Good morning again, Mr. Woods.
Good morning.
Just a few questions to really finish off with in respect of the sequential test, really, which is our last topic. I've got something to ask you on flood warnings and things as well. You'll probably know what I'm going to ask you on that. It won't take long. But in terms of the sequential test, can I just ask you to have a quick look in your framework at paragraph 180, please?
Hundred and
180, yeah. So we can see there that when where planning applications come forward on sites allocated in the development plan.
sorry.
So
The
2024 framework.
2024
Yeah,
framework.
the latest one.
Yeah, it's
You might have to look for it online then.
yeah, it's just seen that way.
All right.
So I just clicked onto the link, and
Link.
it's the wrong one.
Well, I think Mr. Masters is passing you his
Oh.
copy. Thank you. Is it-
Okay.
Just so, in respect of 180, the beginning part relates to the sequential test, and it says, where planning applications come forward on sites allocated in the development plan through the sequential test, applicants need not apply the sequential test again. So in respect of allocated sites, the DS sites, it's right to say that those are deemed to be sequentially preferable by operation of paragraph 180, aren't they?
Well, in accordance with that paragraph, that is correct, of course. However, it would be wrong to ignore factors relating to flood risk to those sites. So if, for example, a site was allocated in the plan because presumably the council have done their sequential test and dealt with it in terms of suitability of allocating the site, and then the site is falls within flood zone 3, well, clearly it won't be sequentially preferable.
Yeah. And of course, so yes, if it fell within flood zone 3, that would be right. But we have got the allocation process that you've seen in the documentation here. The caveat I expect you would make is, well, it can't be available to meet the development needs if it's already been given permission and that permission has been implemented by another Gypsy and Traveller family. And I think you act for the families in respect of DS 18 and 20. So presumably you would say, well, in respect of those, because those sites have been granted permission for people and they're being occupied pursuant to those permissions, those wouldn't be sequentially preferable. Is that, have I got that right?
Well, they won't be available.
Yeah. Precisely.
Yeah.
So we would discount those, but in terms of DS 15, 16, 17 and 19, subject to they've got to consider the flooding point. And of course, the flooding point is considered in the sequential allocation process, isn't it? That's the main thing that it looks at.
It should be looked at in that process, but by way of an example, we are dealing with a large allocated site in Hertfordshire, given local plan. We did various reports, and there's been a requirement for a flood risk assessment, even though the site was allocated. So it doesn't necessarily follow what you're saying.
All right. And in terms of, but looking at the specifics of them, in respect, for example, and this is a separate point really to the 180 point, in respect to DS 15, can I just ask you to turn up again the rebuttal proof of Mr. Smythe, because I want you to have a look at his paragraph 2.15 on page 8 of that. And if you need the reference again, it's CD 10A.4, the rebuttal proof.
Can you give me the paragraph?
Of course, yeah. It's paragraph 2.15 and it's on page 8, Inspector.
CD 10A.4.
0.4.
We've got CD 10A1 and CD 10A2. Was it on one of the specific sites?
So it's
I'm looking under Appeal A.
Yeah, so if you look at CD 10, that's where all of the rebuttal proofs are. And what you need is the last one in that group, which is CD 10, 10A, or the penultimate one, sorry, CD 10A.4.
With respect, it's not.
If you
It's CD 10A LPA rebuttal evidence and CD 10A1 supplementary evidence, CD 10A2 amended appellant supplementary evidence.
So
Am I looking in the wrong appeal then? Because I was told they're all the same.
They are all the same. So I'm looking in CD 10A. So if you look in the folder 4A, CD 10A is called in big black letters LPA rebuttal evidence, and the first one should be CD 10A.1.
Oh,
which is
okay.
specific. Brilliant.
I was looking at the Roman numerals.
Yeah, no, I've done that too. So we're we're alike on that. But no, it's the one before that. You've got it.
Okay, it's the actual evidence rather than the appendices.
0.4. So Mr. Smythe, yeah.
Okay. Thank you.
And then when you're there, you just need to turn to page number 8.
Page 8. Okay.
And the first paragraph there is 2.15. And as with yesterday, this is an appendix within the appendices to this proof, but the relevant paragraph is quoted there. So I'm taking it for ease of reference to that paragraph to discuss the principle with you. But what it says there is that additionally, the appellant looked to compare flood risk, but did not compare the extent of flood risk on the other sites, such that whilst both sites could have the same flood risk, one site may be subject to a lesser area of flood risk, and thus it could be sequentially preferable. So you understand that as a relevant consideration when looking at the sequential test. You look at the degree of flooding on one site, and you could have sequential preference in those terms as well.
You could do.
And in that, to that end, what Mr.
But that's... Yep. You're putting two things to me. You're putting things to me that in terms of allocated sites, they pass a sequential test. Now you're asking, so I'm not quite sure why you're asking for something else when it's not part of your case.
Well, it's just in respect of DS 15, there are overlapping points. So we've agreed the position in respect of the first point I put to you, which is 180. But in respect of DS 15, a relevant consideration, and that's all I'm looking for really, is the degree of flooding on a site, and you've fairly accepted that's a relevant consideration.
It is a relevant consideration, but you need to look into all the other factors in terms of that allocated site. which I've set out in my table.
And we discussed those elements of the sequential test yesterday. So I'm not going to go back over the principle that I discussed with you yesterday, but I'm grateful for that clarification. And would you agree with me as well that in terms of the degree of flooding on DS15, as shown really in your appendices, Mr. Smythe is correct to say that there is a smaller extent of surface water flooding on that site to the appeal sites?
Not necessarily so.
Well, let's have a look.
And of course, according to Mr. Smythe, what will happen is that the flood risk will be upgraded on these sites.
Well, let's have a look at your page 50.
Yes.
Of your appendices. So we can
Of the
see
appendices.
that's DS15, yeah.
Yes.
And I think the point you've made is, for fairness, you should perform a like-for-like comparison, as Mr. Smythe said yesterday. So you, in terms of this site, you would need to compare it with the previous extent of flooding, because otherwise you're comparing something which has been updated for one site, but you're not comparing the same for the other. But the simple point I would put to you is that the area of flooding shown on your page 50 is extremely small, even compared to the previous surface water flooding maps for this site. It's plainly less, isn't it?
It is less, yes, as at that point in time. But what Mr. Smythe is saying is the flood risk has increased everywhere. So this wouldn't necessarily be the case, and also means that the access route, a bit like the appeal sites, goes through an area of surface water flooding. And this was the site, as you will see from the aerial photograph. There's more development on there, and you will know, of course, that the appeal was dismissed to extend the site.
Yes, it's for its, well, I can't answer questions, but you're right. I did the appeal in respect of that particular DS15 site, and
so you need to read it and need to consider it in context.
Yeah. So I mean, it was held that the designation in DS15 was the appropriate number of sites that it would contain. So and that was for 3.
Well, it was also held that the lawful use of the site was for travelling show people.
Could I request a copy of that?
Well, I'm not going to give evidence on it, so I wouldn't ask the inspector. I shouldn't really engage in a conversation with the witness, but it's not relevant to the cross-examination. But
it is relevant, because the site was allocated for travelling show people. They tried to get lawfulness for use as a caravan site and under ground B, and it was found no, because it was different, and it referred to a case of a case in Winchester, which is Carousel Park, whereby it was a travelling showman site, and there's been 3 appeals related to that site. Two have gone to the High Court, and we eventually got planning permission for most of the site for gypsies and travellers. The point being, you can't just extinguish what something is there. It needs a planning permission.
So I mean, we've got the decision. Got the decision in the bundle. It's at Mr. Jarman's Appendix 16.
It is quite an important point for the authority to take a position on, which is that if you've got a planning permission subject to a condition that says it shall only be used by travelling show people.
But that's not the case, Steve.
What the Winchester case was a planning permission for travelling show people, and the limitation was in the description of the development.
Right.
And if Mr. Woods is saying the description of the development is limited, then that's a functional limitation that operates.
Yeah, but what I'm saying is we can read the decision at DS to Mr. Jarman's 16, and we can make submissions on what that decision says. But I'm telling you that what it says is that the allocation is a good allocation for 3 gypsy and traveller sites. So we can all have a look at that and take a view on what it says. But for present purposes, my cross-examination is about flood risk across that site. I've got your answer, Mr. Woods, on that, and the inspector does too, which is that you accept that it's less, but you say that there may have been changes given the new flood mapping. But it's right to say that you've not put anything in addressing the changes by the flood mapping and whether that changes the situation in respect of the extent of flooding, have you?
No, because we're not allowed to put in late evidence.
All right. So, and in respect of DS19, you agree that that's sequentially preferable for one pitch, but you say it's not sequentially preferable to take all the pitches, for example, on site B. That's the position you set out in your evidence, isn't it?
Yes, that's correct. Yeah.
So I want then to move on and look at the plots under sale or auction, and in respect of site number 2 of those within your table, it's right that you haven't provided any flood mapping to support your assessment or address or size information. So from your table and your proof of evidence, it's not clear what basis site 2 is ruled out, other than you say it's not within the search area. Yeah.
Well, that's correct. It's not within the search area.
And in
So it's
respect
not relevant.
Yeah. In respect of site 3, Culmer Lane, you don't provide any information, again, within the table on Culmer Lane. You appreciate Mr. Smith has assessed it in his Appendix D as being sequentially preferable on the basis that there's no flooding issue in relation to it. But it's correct that you've not provided information yourself on that one, have you? Culmer Lane.
Yeah, I understand Culmer Lane. As I said, I'm contacted about it numerous times, so I'm very familiar with the site. And yes, it is correct to say that it is at lower flood risk, but it's partially covered by ancient woodlands and an irreplaceable designated habitat. So that won't be too good for the site, will it? It's immediately adjacent to a conservation area, so brings up heritage issues, unlikely to be acceptable. It's adjacent to the natural landscape, but more tellingly, it's adjoining a public right-of-way which requires access on the public right-of-way to the land. So that's going to be unacceptable.
So in respect,
and unlikely to get biodiversity net gain because of the substantial tree coverage on the site.
So in respect of what you say on pages 54 and 55 of your proof of evidence, you simply say that it's got one lot unsold. So we know that there was more than one lot in respect of Culmer Lane. And you say it's recorded within the 30th July 2024 auction. But you don't provide any further details such as those you've just said orally, do you, in respect of that one?
Are you saying I'm lying, what I'm saying?
I'm saying that we can't see from what we see in 9.50 that you've considered.
I said in evidence that the telling point is the site, only last week I looked at the website and it's still on there, and it's 2 separate lots.
So has one of the
hasn't
lots
been sold? Hasn't been sold.
So has one of the lots been sold though? Could you say that one lot is unsold? No, those 2?
There's 2 pieces of land there. I think they were subdivided into 2 lots because it didn't sell as one lot, so they're trying it in 2 lots.
So they've held one back, have they, rather than selling?
No, they're both for sale. But presumably, someone has already bought other lots along the way there, which would have been a bad decision. Totally unacceptable site.
And in respect of site 1, we discussed that you've removed it. That's the one you talk about in your 9.50. You've removed it on greenbelt considerations, and we discussed that yesterday. But you've accepted that in respect of flooding considerations, it's sequentially preferable.
Yes, yeah.
And in respect of the example that you gave yesterday about the site that you checked, and you said, I think you had found one that was wooded, and you said that in respect of that, that meant that it would cause difficulties in respect of general suitability or general acceptability. But it's right, isn't it, that Appeal Site A itself was wooded before the development.
I didn't see it as wooded. So.
But in terms of, you've seen the aerial photography that we went through yesterday. So you
Seen
can
the
see,
aerial photography,
you can
but
see
that
the
doesn't.
woodland there.
When taking aerial photography, just because something looks green and looks there doesn't mean that there's lots of trees on the site.
No. I mean, we can, and we've seen that in the landscape evidence, we've got aerials of what it looked like. So the inspector can form a view.
If it could have been
from those.
scrub.
Now, in respect of this point of flood warning, it's right, isn't it, that neither of the flood risk assessments, the under or the flume one, refer to any flood warning or flood alert area, because surface water flooding, it's not in an area which would be covered by that.
That's correct. I was asked the question and I gave an answer.
Yeah, I understand.
That could be the case, but it would normally be to do with river or sea flooding that you'd have a flood warning and evacuation measures.
And in terms of just one further question then, Inspector, if you could turn to CD 8.3, so in the same CD, the LPA proofs of evidence for 8A, if you turn to point 3, that's the ecology proof of evidence and appendices.
So are you going to be looking at?
Well, they're all bound together in that one. So I've got them printed out, but what I'm going to try and do is find the page number within the PDF file and go to it that way.
So, sorry, CD 8.
CD 8, and then it's point 3.
CD 8A.3.
It's CD. I've opened it, so apologies. I need to go back out to just check it, because I also get confused with the Roman numerals and things.
Yes.
So it's CD 8A is the overall large title.
Right.
It's 8A.3 for the ecology proof of evidence.
Okay, yes. That's the one you want me to look at.
And what I want you to have a look at within there is Appendix 7. But because the appendices aren't split up, I'm going to need to find you the page number, the PDF page number to go to.
Okay.
So just bear with me while I do that. Page 164. Yeah, well done, Stephen. 164 is indeed the page where it starts.
So is it in one of the appendices?
It is, yeah. And it starts, as Mr. Cottle has just said, it starts on page 124, but the 164. But the specific page that I want, it's a rather long decision because it's the Loddington one. But the particular page I want you to go to is page 190 of the PDF. And the paragraph is 132.
One, 3, 2. Got it.
Brilliant, excellent. So this was a case which we called the Loddington case. It was also Egyptian Traveller development, and you can see that we were having discussions with Mr. Masters there about conditions on that case as well. And at 132, the inspector notes that Mr. Masters suggested during the drainage RTS that I could work on the basis that the surface may not be permeable, but conditions could require a percolation test and sustainable drainage system. On the balance of probabilities, the development, which would also include buildings, mobile homes and caravans, as well as hard surfacing, would greatly reduce the permeability of the site and increase the volume and rate of runoff. And he then goes on to consider various other matters. But I want to ask you a question about paragraphs 138 and 141, just in relation to some of the things you've been saying about the principle of conditioning flooding in this case. So on the next page, 138, it says the council was not satisfied that such a scheme is capable of being designed for this site. And Mr. Jupp and Mr. Hughes said they would have expected a design to be submitted even only during the appeal. We see that at the close of that, on the best evidence available to me, I'm not satisfied that a solution would be presented to store the likely volumes of water prior to infiltration. And then go down to 141. The evidence before me is insufficient to demonstrate that a system along the broad lines proposed by the appellant could manage the likely quantity of runoff. And so he goes on to say he's not persuaded that the imposition of a condition like that would be reasonable. So the simple question for you really is that before imposing conditions in relation to this site and flooding, the inspector would need to be satisfied, wouldn't he, that a system along the broad lines of that proposed would be capable of managing the operation. He can't just do it on the basis that it might be. That's part of the viability considerations as they were put by Mr. Smythe. That's the correct way to look at it, isn't it?
Well, that's the way the inspector came to the conclusion in that particular case. In this case, what we say is that it's a matter that can be properly covered by a condition, and if the inspector has any doubts about it, they could be temporary planning permissions and a requirement to do these things in advance, because otherwise the occupants of these sites will be homeless, with nowhere else to go, coupled with the improvements that could be achieved by the reinstatement of the ditch and possibly the widening of the ditch that was there. All of that put together makes planning gain. So, I've got no reason to doubt why, with percolation tests, because it's something that comes up on other cases. There are ways of dealing with it, with a surface water drainage system where you have crates below the ground and the crates are filled with rocks and the surface is covered and the water goes in there. And yes, the water level may come towards the top of that, but eventually will drain away and go. So we are confident there is a solution. And in fact, Mr. Quigg has put forward such a solution on the appeal, but is not before you, sir. That's on site 1. It's a separate appeal. So there we are.
I'm grateful for that. But obviously, I'll make submissions on legal matters and things relating to conditions as well. But I just wanted to put that point, and that's all the cross-examination, Inspector.
Thank you, Mr. Longton. Mr. Woods, just a few things you can perhaps help me with.
Sure.
Just got a few points of clarification on the flood risk assessments, first of all. Just, sorry, just call them back up. Yeah, the way they're appearing for me, I've gone to the one for site B first, which I think you'll find at core document 2B.10.
If you just bear with me, sir.
Of course, yeah.
So it'd be within Appeal B.
Yes, that's right.
Thank you, sir.
Yeah, Appeal B core documents.
Okay.
Yeah, I think it's CD 2B 38.10. And when you get there, I'm on PDF page 36.
CD 2B10. Ah, yes, getting there. And you're on page 36, did you say, sir?
Yes.
Okay. On there.
That should be a location plan.
Yes.
And of course, this flood risk assessment, I think, was prepared for 3 sites, B, C, and D. We're concerned with B in terms of your evidence, but that I think is a superseded plan. So I just want to check. Am I right in thinking that that's the plan which was taken into account in preparing the flood risk assessment?
Well, that's the plan within it, sir. So yes, that must have been the
Yes.
case.
Yeah.
We were going to check, because I think Mr. Ward refers to plan relating to site B and distances. We were going to double check
I mean, that
what
was one
the
of,
application
that was
plan
one of the
is.
things on my list earlier
Yeah.
this morning, as you know, but I think that's already been agreed that that plan is superseded in terms of the location of sites.
Yeah, I think we did agree that in one of your CMCs, actually, Inspector, as well.
Yes, I think right at the beginning of the inquiry.
But in any event, sir, what we would expect if a permission would be forthcoming would be a
Yes.
site development scheme.
Okay. Yeah, I just want to be clear about the basis for the flood risk assessments. You could just go back in stay in the same document. I've just got 2 more questions on this document.
Okay, sir.
I think my next one is on page 26.
Page 26. Okay, sir.
In the section 6.1, just like clarification on what it says in the very final sentence, bearing in mind that I'm presuming the flood risk assessment relates to what has happened on the site. And the reference to land raising.
Yes, I mean, it states there will be no land raising on site and any new fencing should be hit and miss or palisade design, and that's
But is that
clearly not to impede floodwater.
yes, but is that accurate in terms of the pre-development situation?
Well,
We've heard
I
evidence.
can't.
We've
Yeah.
heard evidence at the inquiry that there
Mm.
has been land raising.
Mm. Yes, well, if the evidence in the inquiry there has been land raising, then that's it's based on there will be no land raising.
Okay. And then the final point on this one that I want to ask you about is my note says page 23 of the same document.
Okay, sir.
And I'm in section 6.4,
Yes.
and the second paragraph in that, and it talks about what I presume what the understanding of the scheme is. If you could just look at the end of line 1 and beginning of line 2.
Sorry, I didn't get your.
The second paragraph.
Second paragraph.
Yes, the end of line 1 and the beginning of line 2. Again, it's setting out how it appears the proposal was considered.
Well, it says, however, given the site is located entirely with flood zone 1, proposed application is for a minor extension. The existing property safe escape is not required.
Yes. Is it a proposal for a minor extension to an existing property?
No, it's not.
Okay, thank you. Go now to the flood risk assessment for field site A, and reference you'll need is CD 28.5. I'm on PDF page 10.
Okay, this is related to Appeal A.
It is, yes. Yeah.
So. I'll get. Oh, sorry. So can I have the core document reference again?
Core document reference is CD 2A.5.
CD 2A.5, yes.
Yes.
Okay, so
PDF page number 10.
10.
Should be a page with a figure at the bottom, a coloured figure at the bottom.
Okay, sir, yes.
I'm going to ask you a question about the second paragraph. But first of all, are there any buildings proposed as part of this appeal proposal?
Are there any buildings?
Yes. Think back to the description of development that's been agreed.
I think that there's a day room proposed.
There is on sites B, C, and D.
It isn't, sorry.
There are day rooms proposed on sites B, C, and D.
Mm.
This is about site A.
No.
The description of development.
On Appeal A, no, there is not a day room proposed.
Yeah, that's my understanding as well. Can you have a look at the second line in that second paragraph?
Yeah, I mean,
Is it accurate?
yes, it says furthermore, the respective buildings will be raised on skids where there aren't any buildings, so no.
Yeah. Thank you. Okay, that's the flood risk assessments. In terms of the development that's taken place on the sites, would it be open to the local planning authority to pursue enforcement action?
Yes, it's always been open for them to pursue enforcement action, and the purpose of submitting the application in the first place, certainly relating to Appeal A, because that's the application we submitted.
Yes.
We had discussions with the enforcement officer of the
Yes.
council, and we said we will submit a planning application. So it
Yes.
has been open to them, yes.
Okay, thank you. And then I think I'm going to your proof. 9.57.
Yes, sir.
And here at the end of paragraph 9.57, you touch on two possible alternatives for dealing with flood risk on the site. One is you refer to appropriate piping, and in the alternative, an appropriate retention basin. In terms of the retention basin, in respect of site A, has any assessment been done of whether there is space for that to be provided on site A?
Well, that was put in my evidence because, yes, in discussions with the drainage engineer, that was possible. I wouldn't have inserted it otherwise, sir.
And you're talking there about the Red Edge site?
Yes.
Okay. I think just one more point, Mr. Woods. And I know you've already been asked about the sequential test, but I just want to be clear on one thing in connection with site A. I'm looking at, so I'm on page 53 of your proof, paragraph 9.45.
Yes, sir.
You say there that A would individually fail the sequential test. And then if I go over the page to 9.54, you there say that the sequential test is found to be passed. So bearing in mind what you've already said in the earlier paragraph, is what you say in 9.54 just a reference to Appeal B?
It is because I accept that for the single pitch on
Yes.
site A would
Would fail.
fail on the basis on the basis of the allocated sites. But I've already been through those and the issues that relate to those sites.
Yes, but you say quite clearly, take a view quite clearly in 9.45. And I just wanted to, so 9.54, we should read that in relation to site B. I think that's what you've just said.
Yes, yeah.
Yeah, that's helpful. Thank you very much.
Okay, sir.
Re-examination. Take it in the same order. Mr. Masters first. If we could, it's been asked about the flume report.
Okay.
I wonder if you could go to the page 16. Sorry, Mr. Masters, that was a bit quiet. Page 8.
Page 8 of 16, with the heading flood risks for surface water and overland flood flows.
Page 8. Ah, right,
Oh,
thank you.
right, yes.
Yes,
Going to pause for a second because I just want to get something else up. Give me just a minute. If you also have up, Mr. The flood mapping that we looked at on the last occasion.
Is this the one that Mr. Smythe put in? Mr. Marshall?
Yes, so we had problems identifying where it was.
this document.
Yes, thank you. And if we could just look at what Mr. Quigg is saying in his second paragraph from Flume have obtained two different surface water risk models. One from the EA, the National Generalised Flood Model. Now we know that's the original document that Mr. Smythe used, that was superseded by this, and I'll come back to that in a moment.
Yes,
One from the EA and the other a proprietary flood model, UK Flood Map 4. In the absence of detailed site-specific or local pluvial flood modelling, the UK Flood Map 4 pluvial flood database was obtained as part of the assessment to compare with the EA service water. The commercial data 2023 is based on a more accurate LiDAR ground elevation data and flood flow routing modelled and used by the EA. National model, which was published in 2013. So it's based, as I understand it, on a LiDAR of 2023, and we can see the model below. And
Okay,
we can
yep.
see in relation to Appeal A, a point at that point in time that Mr. Quigg was seeking to demonstrate is that there was no service water flood issue on Appeal A, and that was his conclusion at that time.
correct.
We know that Mr. Smythe says that the new model is based on 2019 data.
Sorry, the what model?
The new
Yeah.
plan is based on 2019 data. We can see that that new plan has the flooding, service water flooding, going into the site.
Yes, it shows that, yeah.
I wonder if you could, you question that and the basis upon which that information is dated 2019, and you think it's later. I just wanted to ask you this: if we have LiDAR data based on 2023, but doesn't come near to the site, what is more likely to be the case? That the 2025 mapping is more recent
Yep.
or not?
Yes, more recent, it should be covered by the more recent data that's available from 2023, not from 2019. There would be no purpose of doing it from 2019.
What confuses me, and I really want you to comment on, if the 2023 LiDAR didn't get close to the site, and the EA are now using a mapping system of 2025, would that suggest that the LiDAR is even later than 2023? In your view, or not?
Well, it must be something different, because looking at it from the 2023 LiDAR, there is no flood risk issue relating to the site. One can only speculate on what might
We
happen
know
after that.
we know that what happened at some point in time is that the watercourses have become blocked.
Yes, which was after the dates of the flood risk assessments. I was taken to points in both flood risk assessments where there's reference to a ditch.
So what in your view do you think is more likely to be the explanation as to why the most recent data show something completely different than the position was in 2023?
I think the logical explanation, when you look at it, there wasn't in terms of 2023 data, there wasn't a surface water problem. If you've got water flowing that then flows down an open ditch and suddenly you block it, then that's going to cause an issue, and that's what's caused the surface water flooding.
So in your view, if there is a condition relating to the issue that you say has occurred, which is a blocking of the ditches, does that also include raising of ground levels?
Well, that would have to be part of it as well, because the ditch, as I said in answer to the questions, could be wider than what it was originally, and there would need to be an assessment to see whether raising of land levels the other side would cause a problem. I suspect they wouldn't cause a problem if the ditch was reinstated and the water allowed to flow through it rather than accumulating on the land.
So what the inspector needs to decide is why we didn't have a problem in 2023 when these reports were prepared and why we suddenly do. And if that problem relates to the blocking of the ditches and the raising of the land, is there, in your view, a simple solution?
Yes, there is, yeah.
And what is that?
The simple solution is to reinstate the ditch, and when you're reinstating the ditch, you could make the ditch wider or deeper to help and be an improvement.
And could that be done by condition?
Yes, it could. Yeah.
Now, you were taken to, and I was reading something else as Stephen was taking you, Mr. Lintoff was taking you to it. I think it's one of our Bedford cases we did, where she quoted from the inspector's reports, but relating to whether or not a condition could be imposed.
Liddington, yeah.
Was it Liddington?
Yeah, it's Loddington one.
Loddington.
It was Mr. Brown's disaster when he was ill. Yeah, okay. Won't go to that. Okay, it was a Loddington decision.
Loddington.
Now, if we go back to paragraph 28 of the PPTS and the second sentence, local planning authorities should consider how they could overcome planning objections to particular proposals using planning conditions or planning obligations, including, I won't go any further. I wonder if you could comment on that change in the context of how councils were generally approaching issues before that date, about they needed to see the details before a condition could be imposed.
Yeah, I mean, there was a sea change to try and accelerate provision of development and not to withhold permissions that can be covered by a condition, even if those elements relating to that are not before the council at that stage. And that will be a pragmatic way and sensible way of progressing, that you use planning conditions wherever possible to overcome planning objections.
Thank you. Can councils now get away with saying, oh, well, we just don't know, and therefore we shouldn't be imposing a condition because we don't know?
No, I think that's the easy way out, and it's unfortunately it's used sometimes as a method, a stick to beat the appellant with, to say that things can't be resolved, but there is always an engineering solution.
Incidentally, if we look at the under report, which you also have, that again, that's dated July 23, And it also comes to a very similar conclusion about surface water flooding, doesn't it, at that time? It's 25 of 30, 29 of 32, sir, discussion and conclusions.
Yep.
And it's
What core document is it?
it's
please?
the bottom penultimate paragraph. The EAA risk of flooding from surface water map suggests the site is within the areas of very low risk to flooding from surface water.
Yeah.
And then- Sorry.
What core document is it, please?
Oh, sorry. Forgive me. You were taken to it. It's in. Sorry, it'll take me a minute to tell you which core document it is, but I can do that.
Brian, it's two.
I'm grateful to you,
You've
sir.
got me, but-
Sorry, CD.
Sorry, Mr. Woods. I thought you'd be able to turn it up. The trouble is, you see, I'm using the hard copies still, which means I can get there quicker. Have you got it? It's and I'm on pages 29 of 32. But someone's going to say that's not the right page because it's an electronic version in a minute.
No, the electronic version is the same
Is it?
page numbering on this one.
Thank you. And then it's
And the ongoing report is in.
it's in I think it's Appeal B.
Referred to Appeal B, aren't you?
Yeah, it's in Appeal B. And you'll see it flags up immediately as a strategic flood risk, sorry, not strategic, the FRA as a document. You did have it because you.
Yes,
you
I know.
spoke to-
I know I did have it, yeah.
Take your time. Sorry, sir. I think in a few years' time, sir, all these electronic things will be much better and you'll be able to find things much quicker.
I saw something that said, just while Mr. Woods is finding that in 5 years' time, you won't have on your phone all of these different apps that we've all got. What you'll have one combined AI that you just ask for what you want, and it takes you automatically into whatever the process is to find it, rather than the individual app.
Oh yeah, it'll be
So
Star Trek.
We'll just
computer.
basically, we will be,
Yeah.
beam me up, Scotty, and we'll be
Yeah.
beamed up. So.
Yeah.
Yeah, exactly. That would be, I mean, if Mr. Woods, that'd be great. You could just say to your computer, can I have CD, whatever it is, and it would just come.
Can you just
straight
take me to it?
I-
Too much noise going on to concentrate my brain on it, so.
Give me a second and I'll give you my copy, but I'll just find it in this copy. I think it's in the application documents.
No.
And it's,
For some reason I can't get to Appeal B, but it's
Don't-
my, dare I say, Luddite approach to these things.
If it's yours, that's mine too. Mr.
well, I tell you,
dear.
I'm having a problem.
If you just read the paragraph out to me, that'd
Yeah,
be
I
a quicker
will
way
do.
of doing it.
So on page 29 of 32, there's penultimate paragraph, the EA risk of flooding for surface water map suggests that site lies within an area of very low to low risk of flooding for surface water. And that was the position in 2023. And if we turn over the page,
Similar to the Flume report.
exactly, and it's just consistency, just all I'm taking you through. And then paragraph 3 down, according to the Waverley Borough Council strategic flood assessments, there are no records of surface water having affected the site previously. According to the Waverley Borough Council strategic flood risk assessments 2018, the site is not located within a critical drainage area. So in other words, it appears the concerns that have now manifested themselves have arisen since those mapping exercises were done, and comes back to the point about the likely cause that we've taken you, that I took you to a few moments ago.
Yes, I mean, the likely cause is the blocking of the ditch.
And if I could, just to ask you questions about Appeal A, okay?
Yes,
Appeal B, we've already established the area of where the caravans are and people are is not subject to surface water flooding. But in relation to Appeal A, we have a situation where technically on the mapping produced for the first time by Mr. Smythe, we do.
correct.
Okay. We have solutions for that in terms of raising the ground levels, plans and matters of that sort. The inspector has already identified. What I wanted to ask you simply is this. Is there any definitive evidence about either depths or flows of surface water flooding?
I haven't seen any, and the point about the surface water is coming and running along towards Stovolds Hill. And if you block a ditch, the reason why they're showing hauling at Appeal Site A is because of that very point. There's backing up and the water is finding the simplest way to stay where it is. It goes to the lowest level. And if it's blocked and it backs up.
It's on a hill. So in your opinion, are the depths likely to get to any level to cause danger to life?
No.
What's going to occur?
What's going to occur?
Yeah, how does gravity work?
Well, it goes downhill, yeah.
So it doesn't stay on the site
No.
defying gravity.
No.
And so the suggestions that we get to 300 mil, 600 mil, 12 inches, 24 inches, there were suggestions of Mr. Smythe. What's your opinion of the reality of that?
I think it's a remote possibility, but in any event, the caravans used for residential purposes are always raised above ground level. You have steps up to the caravans, so it will be below that level in any event. So the occupants will be safe, even in the worst case scenario, without the ditch being reinstated and there being a problem on the site.
Thank you. Of course, both of these reports complied with the current position in the PPG about having FRAs, but identifying no need for sequential approach, which we've already given evidence on.
Yes.
Inspector, that's obviously a leading question.
Well, no, it wasn't a leading question because I was just covering something we've already done. I'm now coming to my question. But the situation has now changed in the sense that Mr. Smythe has now produced this further map and said, oh, well, the mapping's changed. We've now got this problem with blocking the drainage ditches and the potential raising for the ground levels, for which you've given a solution. Well, that's quite simple. You just return the site to how it was before by condition.
Exactly.
So, forgive me, the question I'm now coming to is, bearing in mind, therefore, your solution is a condition. Is it your view that there is a need for looking again at sequential tests? I know you've done it anyway, but
Mr. Masters, I'm concerned that you're inviting Mr. Woods to resign from evidence he's already given.
well, I understand where you're going, sir, and that's why I caveated it by saying I know that your view is you've done it anyway. But
he's been quite clear in his answers to questions from Mr. Lintott and myself on this.
Yeah. What he said, sir, as I understood on a number of occasions, is we've done it.
He's not only said we've done it; he agreed it was appropriate to do it.
With a caveat, I thought, sir, which was that but he has done it, but he didn't, but the new, PPG, suggests that it might not be mandatory.
Well, it depends on the circumstances, but the question, the matter was dealt with quite clearly in discussions between Mr. Lintott and Mr. Woods.
If you think that I'm being unfair and inviting him to do something that he's already on, but I won't pursue it, sir.
I'd be grateful if you.
I'll leave it there, sir. I thought there was a nuance, which is why I was going to go back there. But I mean, it is our case. We've done it anyway. But I'll leave it, sir. I won't go there. So we've already gone in. I'm not going to go back over the details of the way that you then carried out the sequential test and matters of that sort. But there is a major issue on this approach that Mr. Smythe says, oh, well, the sequential test is about only looking at sites in areas of lower risk, flood risk. And you've been cross-examined on that on a number of occasions, and you say that's nonsense, don't you?
But it's not just that alone. You need to deal with it in the round. There's no point. In answers to the question, there's no point having a site that's in flood zone 1, no surface water problem whatsoever, and that must be sequentially preferable. Well, in theory, yes, but you have to look at all the ramifications for that particular site. There's no point proposing, saying, oh, that's flood zone 1, so that's fine, when lots of other indicators say that the site will be wholly unacceptable.
And you remember there's a lot of cross-examination on this, up and down, and Mr. Lintott was saying, well, you're wrong, and Mr. Smythe is right. And then you both examined that one example case that of the site in the green belt in an area of ancient woodland, etc. Do you remember that?
I do, yeah.
Do you also remember when I took you to the planning policy, the changes in the planning policy guidance? On this?
Yes.
And I'd like to go back, if I can, to paragraph 27A. Do you have it?
Really?
If you don't, I can give you another copy.
I've got it. Okay.
Okay, and on the could you find 27A? It's the second page, and it's the second, and I'm going to ask you to read out, if you can,
Yes.
the second sentence down. Just read it out and comment on what it says in the context of the position taken by Mr. Smythe and Mr. Lintott and the position taken by you.
Yeah. It says the sequential test should be applied proportionately, focusing on realistic alternatives in areas of lower flood risk that could meet the same development need. So focus on that proportionately.
Just
yes.
pause a second.
And then
the inspector hasn't got it yet, Mr.
Oh,
Sorry, sir. I didn't think you had. You carry on. I shouldn't have stopped you. Carry on.
right. Focusing on realistic area alternatives in areas of lower flood risk. So pause there. Realistic alternatives. So just because it's in a lower flood risk area doesn't mean to say that it's a realistic alternative to meet the same development needs. So in this case, a gypsy and traveller site. So you need to look at the PPG, is looking at it, is it a realistic alternative? Well, if it's partly on an ancient woodland or joining an ancient woodland and access would have to be down a public right of way, and you've got a conservation area opposite, it's not a realistic alternative.
Thank you. So is it a question of just identifying for the sequential test on any area that's available in a lower flood risk, or does it have to have those additional features? In other words, a realistic alternative to the same development need, as well as a lower flood risk?
Yes, that's correct. It needs to have those things. So it's not just looking at saying, oh, well, that's at lower flood risk, so that's okay. It has to be a realistic alternative, and that's what Mr. Smythe hasn't done in his assessment.
And then
Mr. Masters, I think Mr. Woods has made this point now in examination in chief, in cross-examination and in re-examination. So can we
yes, sir.
move on, please?
Yes, sir. Sir, but in which case, sir, but those are the re-examination points I had.
Mr. Cottle, do you have anything for Mr. Woods?
I do. Just on the flume report, which is CD 2A5, and it's page 14 of 16, electronic page 15. Third paragraph,
Page 15.
or it's page 14 of 16, but
14, okay.
well, I just want to find it. It's the third paragraph, third line.
Is it the
That
heading?
can't be on page 14.
Is it the heading flood mitigation measures?
Thank you.
And it's the
Okay.
paragraph that begins external ground levels.
Yes.
And it's the second sentence. What do you understand by channel drainage system?
Well, it's you have a gully and covered by a drain cover, and then the water will go into that and then drain into a basin or into the ditch.
Now, yesterday we were talking about a discussion between the lead local flood authority and the planning authority, email discussion.
Oh yes, yes, I remember that.
And one of the points there was that the runoff from the developed site would go into the watercourse. How would it get to the watercourse? What would be the vehicle, the route?
Well, it would be by a channel, a drainage channel.
My lady friend was putting the Loddington appeal. Was there a watercourse that the site runoff could go to, adjacent to the site?
No,
in
there
that
was
case?
not. No.
And is there a difference in between raising caravans and raising land?
Yes.
Could you explain that to the inspector?
Well, the caravans would naturally be raised above ground level because that is the nature of a caravan. There will be steps up to it, and it will be raised, and there'll be flood storage if there's necessary underneath. Raising ground level would mean the whole thing would go up, but then you'd have to make sure that by raising that ground level, you're not causing problems elsewhere. But the solution must be, when you look at the reports that are there, was what was the situation when they Flume and Onga did their reports, and it was that the ditch was there, and there wasn't a surface water problem. So you reinstate the ditch, you have channels going with the acro on the top, the drains like French drains going to into the ditch to make sure any water on the site drains away.
Is it possible to have a planning permission for a caravan site that requires the mobile homes to be raised off the ground and for there to be no concrete apron blocking the underneath of? Is that,
Yes,
is that a
it's
feasible
fairly commonplace if it's required. Yeah.
And what about the step access that would have required to the caravan? That would be a built structure, would it? Or
Well, not necessarily. Well, it will be a structure, but it could be a metal frame, as it were. You're going up the steps. There are metal which are with holes in it.
Right.
So it's a construction as such, but quite simple to manufacture.
And how high could the caravans go? Because obviously we dispute Mr. Smythe's reckonings, A, because it's on the basis of an unmanaged situation with a block watercourse, but B, because he hasn't done the modelling, and I think we agreed any modelling would be required to have an accurate idea of the extent of flood depth.
Yeah.
But the point is, how high could a caravan be elevated in your experience when it's put on blocks or
Quite easily,
or stilts?
0.6 of a metre will, that's, and probably be slightly more than that in reality.
And as regards Simon Doherty's site, in your understanding of the evidence, would there be any residential use within the areas at risk of flooding?
No, there would not.
Uh,
Even in the worst case scenario.
And what do, right, okay. I,
So,
Mr. Lintott, we're next due to hear from your next witness, Mr. Sibbert, but I'm going to suggest we take mid-morning break now.
Yeah,
As
I
it's
mean,
pro-
and your hands up would be sensible though to allow him to get set up.
Yes.
Yeah.
Yeah.
When do
So
you think, Inspector, we should come back?
I was thinking of 11:05, 10-minute break.
Fantastic.
Yeah.
Thanks.
Adjourn now, please. Thank you. Right, time for the inquiry to resume. Mr. Lintott, I've got a time estimate for examination chief of an hour and a half. Do you think that's still about likely?
I think it probably is, just because we need to go through.
Yeah,
some
that's
of the
fine. I was
reports
just
we have.
thinking of
Yeah.
thinking ahead to how the day is going to pan out. If that's the case, my intention will be to then to take the lunch adjournment at that point before we go onto questions.
Well,
Mr. Cottle.
I know it's unusual because there are third parties here, but I do think that third parties have closely followed this appeal and are quite familiar with what is being said in relation to ecology. And in fact, Mr. Ward's proof at paragraph 6.51 says it in about 3 sentences, which is it's a planning authority's case that there's been a loss of habitat, an absence of sufficient survey, and the loss of habitat cannot be mitigated against. Now, if those are the 3 prongs to the local planning authority's case, it would be quicker if my learned friend could reduce his examination in chief to the points that we're taking against it. And we could go straight into cross-examination much sooner. Because his statement, his rebuttal statement, and the supplementary statements would all deal with those 3 points taken as read. But that can sometimes be to the disadvantage of members of the public. I understand that.
The corollary to that is that this is a particularly sensitive issue with members of the public, and we haven't discussed ecology issues at all up until this point. And I will obviously reduce the matter into specific topics and go as quickly as I can, but I'm certainly not going to cut down on issues because my learned friend says that would be his preferred approach. I think we ought to get through the evidence today on those issues, but Inspector, I've given a time estimate. I've not been over any of my time estimates so far.
Yes. And I just remind the appellants that time estimates were asked for from all parties and the appellants haven't produced any. Just whilst we are thinking ahead though, one point which it would be helpful with, I think it's for the appellants to clarify would be the expectation in terms of witnesses on the next topic area, which is personal need and circumstances. What I've included on the timetable are all the appellants for the 4 appeals, but I only have documentation in respect of 2, which is in respect of sites A and B. I've got nothing for sites C and D, as I said earlier.
I'm going to call.
That's what I want to check, so I know who to expect.
Yeah,
So,
I'm going to be calling Matthew Doherty and it's Mark Doherty, isn't it?
Mark, the note I have is that Mark Doherty is appellant C,
Yes.
but he's a joint appellant with Alana Doherty. So what's the intention? One or both?
1.
Mark,
Yes.
so I can write. So I can
And Matthew for
appellant
appeal.
for site D.
Yes.
Right, so they're both. What about site A?
I'm going to be calling
Thomas Doherty.
Thomas.
Yeah, so you've got 3 witnesses on person.
Yes.
Okay. And what's the position with Mr. Rowe? You suggested yesterday he may appear for under personal circumstances. Can I take it that won't be the case, or
I don't think it will be the case, sir. I'll update you if it changes, but it will be.
but at the moment you're just expecting the 3?
Yes.
And what about you, Mr. Cottle? Are you calling Simon Doherty?
I am.
Yeah. Okay, thank you very much.
I'm very grateful, Inspector. So, and obviously I'm cognizant of Mr. Cottle's underlying intention, which is trying to make progress as quickly as possible. And I will, of course, try and do that. And I will, rather than reading sections of the evidence, I will concentrate the examination in chief on 4 topics, Inspector. Firstly, what were the habitats pre-development, the topic, first topic? What were the species pre-development for the second topic? What was the impact on habitats would be the third topic, and what would be the impact on species would be the 4th topic. And then finally, a sort of mop up on any mitigation compensation arguments. So that's the way that we're going to go. I am happy, Inspector, in respect of pages 3 and 4. It would only take Mr. Sibbett 2 minutes to read that through. I don't tend to, as you may have picked up, read the qualifications and experiences to witnesses and ask them to confirm it. I tend to just have them read it through as one block. But I'm happy to take it from you as to whether or not that would be helpful in the circumstances where we are. It will probably take him about 3 minutes to read 1.1 to 1.7 to give his details there. You don't really need it.
I don't need it.
Yeah,
The documentation is there on the website.
so people can
And
read it if
People
they
can
want to.
access it, yes.
I'm grateful. Thanks very much, Inspector. All right, so Inspector, in that case, we've got Mr. Just for people who are rummaging around with documents, we've got the main proof at CD 8A.3, and we've got the rebuttal proof at CD 10A.1.
Yeah.
And also, Inspector, the key documentation relating to this is obviously the ArbTech report, and that's at CD 2A.6. And that's in respect of obviously Appeals A. And then there's a similar catch-all sort of report by Darwin Ecology in
Yes.
respect of the others, and that's at 2 and then B, C and D.11. So those, and the other documents in Appeal A immediately follow on insofar as relevant from CD 2A.6. So with that in mind, good morning, Mr. Sibbett. Could you please start then by helping me with my first topic, what I've called topic 1 or topic A. What were the habitats pre-development? And I want you to deal with this in respect of Appeal A first. And I want you to help me by looking at the ArbTech ecological appraisal at CD 2A.6 to confirm that.
Thank you. Could I just check the microphone is working?
Yep.
Okay. So in the ArbTech preliminary ecological appraisal, CD 2A.6, I'm looking at page 16. And it says the site appears to have previously been broad-leaved semi-natural woodland. This is representative of the deciduous woodland habitat of principal importance under Section 41 of the NERC Act 2006, as identified through a review of the MAGIC database.
And can I just ask you to help us then, you explain in your evidence, what the significance of that rider, Section 41 of the NERC Act 2006 is for the inspector in this case?
The habitat of principal importance is included under the local plan policy NE13 as a site with a local designation which has particular importance and protection given to it.
And in respect of that, that's not a policy we've looked at so far. It's a policy within your proof of evidence at page 7. Can I just ask you to just very briefly explain what that policy provides for and where we find the NERC rider within there?
So on page 7
of your
of my
evidence.
proof, paragraph 3.2, I list out policy NE1. So and in Roman numbers 3, it discusses sites of nature conservation importance, local nature reserves, local geological sites, and other ancient woodland, ancient and veteran trees, or any other priority habitats not identified within 2. And in brackets, it says local designations. So explaining that any other priority habitats are also local designations.
And what does it tell us in terms of policy in respect of those local designations then?
It goes on to say within locally designated sites, development will not be permitted unless it's necessary for appropriate on-site management measures or can demonstrate no adverse impact to the integrity of the nature conservation interest.
Okay, so that's the woodland. You also in your evidence speak about the baseline, including the watercourse in the form of a ditch. So whilst we're there, on page 8, you've flagged up policy NE2. So can you just at the same time, for speed, just help the inspector with how that policy is engaged, if it is, in respect of the baseline for site A?
Yes, there's no doubt there was a watercourse on site A, although the Arctic report we just looked at and didn't mention it. Policy NE2 is about conserving the watercourses. So the council will seek to protect and enhance benefits to the existing river corridor and canal network, including landscaping, water quality, or habitat creation. This will be partially achieved on development sites by retaining or creating undeveloped buffer zones to all watercourses of 8 metres for main rivers and 5 metres for ordinary watercourses.
All right. And then, so if we move on to the habitats pre-development in respect of appeals B to D, I think that takes us to the Darwin ecology, where we've got, I'm going to say identical, save for the plot numbers, but very, very nearly identical, if not identical, reports that have been done for B, C and D at 2B.11. So I'm going to take you to the one for B, just because that's the one we're discussing most in these appeals. I did, yeah. It's 2B.11, and it's page number 4. So what's the situation in terms of that first issue then, habitats pre-development in respect of those 3 sites?
The Darwin ecology report says that habitats, this is 1.2 paragraph, so on page 4, habitats recorded within the development boundary comprised of hard standing, improved grassland and a mobile home. And
do you deal with this in your written evidence, but can you just summarise what you conclude in respect of the adequacy or otherwise of that summary for the baseline purposes?
I conclude that description is the post-development situation rather than the pre-development baseline, sir.
And what do you conclude in respect of, if you take the approach in appeal site A and look around the site and identify what the site would have contained pre-development, what do you take that to be?
Before development, the site contained there's the same lowland mixed deciduous woodland habitat of principal importance in the south, a part of the watercourse, and unmanaged grassland with scattered scrub.
And you provide a description of the various species and things that would have contained within your paragraph 4.9, I believe, in respect of your main proof of evidence. So I'll leave the inspector to read that. In terms of those appeals, B to D, do the comments that you make in respect to policy, NE1 and NE2, do they apply equally in respect of those appeals or not?
Yes, policy NE1 applies equally in relation to the woodland, which was on those sites, and policy NE2 applies equally to the watercourse, which ran through the sites. Yes, sir.
So, Inspector, then if we can trot along to topic B then, what were the species pre-development? And again, dealing with them in the 2 sites, and again, in relation to the 2 ecology reports that we've been provided. So dealing with A first, can I ask you to go back to CD 2A.6, the Arbtech preliminary ecological appraisal, and go to page 17 of that document and help us, please, with what that concludes were present prior to the development.
So the table on page 17 of that ARBTEC report, or starting on page 17, lists several species. Firstly, in the row for amphibians, the top row of that table, sir. The third paragraph, the final sentence on amphibians. The woodland adjacent to the southwest and formerly on site may have provided amphibians with refuge opportunities, but the site in its current state has negligible value.
And then just taking us through in respect of all of them, where the conclusion is the same, then feel free to deal with them as one. But I can see we've got reptiles underneath. We've got badgers, we've got bats, dormice, hedgehogs, riparian mammals, birds, and invertebrates going down to the bottom of page 19. So in respect of those, what are ARBTEC saying in respect of those species then?
So for reptiles, there's the same wording as there was for amphibians. The woodland adjacent to the southwest and formerly on site may have provided reptiles with refuge opportunities, but the site in its current state has negligible value. For badgers, again, the last sentence in that table of badgers, just over the page, so the woodland adjacent to the southwest and formerly on site may have provided badger with foraging opportunities, but the site in its current state has negligible value. For bats, there's similar wording again, the last line in the bats table. The woodland adjacent to the southwest and formerly on site may have provided bats with roosting, foraging and commuting opportunities, but the site in its current state has negligible value. For dormice, the woodland to the southwest and formerly on site is likely to have lacked a mixed habitat and diversity and was likely suboptimal for foraging, commuting and nest building dormice. For hedgehog, again, the table goes over the page, sir, to the top of 19. The woodland adjacent to the southwest and formerly on site may have provided hedgehogs with refuge and foraging opportunities, but the site in its current state has negligible value. And riparian mammals, it includes otter and water vole, are anticipated to be absent. For birds, the woodland adjacent to the southwest and formerly on site may have provided an abundance of suitable habitat for nesting birds. However, the site in its current state has limited nesting opportunities. And for invertebrates, this is the last one on page 19, so on that table. The woodland adjacent to the southwest and formerly on site may have provided suitable habitat for a diversity of invertebrates, but the site in its current state has negligible value.
Now, we also have at CD 2A.7, so the next CD down, a document from Darwin Ecology. And I just want you to turn that up, please, Inspector. And in particular, Mr. Sibbett. Yeah, this is the Darwin Ecology. We've been looking at the ARBTEC at CD 2A.6, but the next one is a Darwin Ecology document at CD 2A.7. And in particular, Inspector, it's page 2 that I'd like you to have a look at, the third paragraph down. And Mr. Sibbett, can you just help us with, of course.
This is the election, 15th of January.
That's the one. Thanks, Inspector. And on PDF page 2, paragraph 3, we see that the writer of this document has addressed their mind to the pre-development site and what they feel about its intrinsic ecological value. And Mr. Sibbett, I'd like you just to take the inspector to that, please, and explain that.
The report says it was assessed that the woodland habitat surrounding the site and the woodland habitat of the pre-development site has moderate to high intrinsic ecological value and offers good opportunities for protected and notable species.
All right. And so I would like you then to help the inspector with your views, and you explain within your proof of evidence in detail at paragraph 4.6 and elsewhere where that is, whether you agree with the baseline situation as put forward in the documentation, and whether there's anything that you want to draw the inspector's attention to add to that, if there is.
No, I agree with the baseline of the woodland, although the watercourse hasn't been mentioned, and then there was definitely a watercourse, and all the various protected species mentioned by Arptec. I think they mentioned those species fairly.
And then in respect of your evidence in relation to additional matters, you've made some comments upon the wood-white butterfly and newts, and I'd like you, great crested newts, sorry, I'd like you just to address those two issues then. Firstly, the position in respect of wood-white butterfly in relation to appeal site A, and then this position in respect to great crested newts.
There's a reasonable likelihood of wood-white being in or close to the sites. Now, wood-white is a species of principal importance, so, and has some legal protection. It's a plant of long grassland and scrub, and it particularly lives in sheltered places. So the habitat on Appeal A wouldn't have been suitable for it to live in, but the woodland in Appeal A certainly would have provided shelter to help it live on the adjacent grassland.
Sorry, Mr. Sibbett, I just want to make sure I've picked that up. Did you say that the site A would not have been suitable even pre-development?
It would not have been suitable pre-development, but it provided shelter for that species on the adjacent grassland. So it had the benefit of improving the habitat of adjacent grassland only. Yeah.
I see. Okay, thanks. And that's just talking about A.
This is just for A.
And then again, just dealing with A first again, great crested newts. Now we can see we've got a document in respect of those at CD 2A.8. So the next document down the line, Inspector, from the one we just looked at. And yeah, it's another Darwin one, Inspector. I'm grateful. And Inspector, I'd like you to have a look at the fourth paragraph in the under introduction and background within that document, which starts the pond. And the question for you, Mr. Sibbett, is we can see the pond P1 on the eastern boundary of the site and the ditch D1, which was situated on the western border of the site, were assessed. I just want to be clear as to what is being assessed in those ponds. So the way to do that is to look at some pictures, I believe. So can we go back to the previous document, so the 2A.7 document, the last 2 pages of that, which has pictures of both P1 and D1, so we can see what's being referred to there.
Okay, so in those photos at the back of CD to 8.7, there's image 2, which D1, the wet ditch within the woodland to the west of the site, and image 8, broadleaf woodland to the west of the site, showing the same water. It's called a wet ditch, slightly surprisingly, because it looks like a pond which has been formed by site A damming the watercourse.
And in respect of the position to the east of the site, we've got image 3 there. Is that your understanding of the what's being referred to the eastern part of the site?
Image 3, they're calling pond 1, the pond to the east of the site, which is a section of the former watercourse, which has been cut off from the water by the hard standing in site A.
So if we go then from there, Inspector, to back into your proof of evidence, which is at CD 8A.3, we can find a figure at the back of your proof of evidence, which shows various matters in relation to ecology and the surrounding area. And I'd like us just to turn that up. Now, I've got a hard copy, Inspector. It's the figures, yeah. It's the very first picture, sorry, the very first plan after figures, coloured plan. And so the short question for you, Mr. Sibbett, is we see that you've identified a pond there, which is about 110 metres to the west of Appeal Site A. Given what you've just told me in respect of the pictures and the report at 2A.8, was that pond ever surveyed for great crested newts?
That pond never was surveyed, so.
And in terms of just to trace that point through, can I also ask you to have a look at Mr. Jarman's proof of evidence, where we've got the Burnt Hill decision we referred to earlier this morning, and in particular, if we turn to CDA 8.4, Appendix 16, I'd like you to refer to paragraph 64 in that. So, Inspector, it's CDA 8.4, and it's Appendix 16, and it's paragraph 64. Yeah. When you get there, Inspector, it will be on PDF page 13 of that decision. Fantastic. Page 13, yeah. And so paragraph 64 is dealing with great crested newts in the Burnt Hill case. And it begins by saying where advice is given, and it then summarises that advice saying, this indicates that a survey should be requested where there is a suitable water body, such as a pond or ditch, within up to 500 metres of the development, even if it only holds water for some of the year. This suggests that a survey would be appropriate in this case. Although the pond is evidently recent, the evidence of Mr. Hutchinson, which I accept, was that the great crested newts can colonise ponds quickly, and certainly within the approximately 4 years that this pond has existed. And then he then went on to refer to the plans in relation to that. So really, it's just a question in relation to the scheme before the inspector and the pond before the inspector. Do you have a comment on that in relation to the pond that you've just said hasn't been surveyed in this case?
So the pond which was surveyed immediately to the west of Appeal Site A was surveyed in 2024, and it's perhaps a couple of years old. And so it's now perhaps 4 years old. And if great crested newts were present in the thatched house farm pond, so that's the pond 100 metres to the west. There's been two more years potential for colonisation of the pond immediately adjacent to appeal site A.
Sorry, Mr. Sibley, I'm just getting a bit confused about this. Are you saying there are two ponds?
So
And one has been surveyed and one hasn't?
the ponds discussed in the Darwin Ecology Report we just looked at,
Yeah,
looked at the ponds immediately to the east and immediately to the west of appeal site A. So in my figure 1, there's another pond 100 metres further west.
I think, but actually it's 3 ponds because the Darwin identifies 2 ponds and Mr. Sibbert's talking about a 3rd pond. Is that right, Mr. Sibbert?
no, hang on, Mr.
Yes,
Well,
So-
Mr.
so-
Sibbert,
yes.
So-
You're not asking questions now.
Well, you
So, so yes, the pond that Mr. Sibbert's identified, Inspector, is the one that's referred to in the document in the architect report, because it talks about on page 17 a pond which is 110 metres away from the site, and so it's within the 500 metres. If you look on page 17, the 3rd paragraph under amphibians, and so the point that Mr. Sibbert has made is that, well, that's the pond which they were talking about surveying, but the pond that's actually been surveyed, insofar as one's been surveyed to the west, is the one immediately adjacent, not the one that's shown on his plan and that
So
he's just referred
so
to.
the one on the plan is the one mentioned in the architect report,
Yeah, that's right.
and there's another one which isn't shown on the plan.
Yeah, because that's the one that is in the picture on the next appendices. The Darwin Ecology one, the pictures they've taken make it clear that's the one immediately adjacent on the west-hand side, rather than the one that's 110 metres away.
We have got in the inquiry documents the thatched house farm conditions for the development which was assessed regarding Greater Crested Newts.
So it's that pond, Inspector.
Right, and just so I'm clear, is this the one, Mr. Sibbert, that you referred to in image 2? And you were surprised it was a wet ditch when it was a pond?
That one was the one immediately to the west of appeal site A.
Yes. Is this the one we're talking about?
I'm talking about that one and the one 110 metres west of Thatched House Farm.
And there's one further west as well, which is shown in your plan.
So the one further west on my plan is the one 110 metres west,
Yes.
that Thatched House plan, yes.
But the other one is the one that's in image 2.
The other one in image 2 is immediately adjacent
Yes.
to appeal site A,
Yeah.
yes. Yes, so sorry for the confusion, sir.
Okay, thanks.
All right, thanks, Inspector. And so moving then on to appeals B to D, we've got, again, in the CD 2B 11 documentation, we've got the areas to be affected by the proposals have been assessed as providing negligible potential for protected species. So that's what we looked at in respect of the previous summary. I won't ask you to turn that back up, but can you just help the Inspector with what you say in respect of appeals B to D then, that was there pre-development?
Yes, the Darwin Ecology took the post-development situation as if it was the pre-development baseline, so I don't place any weight on that. So the woodland, which had been removed from appeals B, C and D, was similar to that approved from appeal A, so possibly I don't need to repeat that. But the open habitat north of the woodland within appeals B, C and D contained open, unmanaged long grassland with various or scattered scrub and maybe scattered trees. And that grassland would have been suitable for a range of species such as reptiles, breeding birds, invertebrates, hedgehogs, badgers, bat foraging, and in particular the wood white butterfly. The grassland did contain the plants meadow vetchling and bird's foot trefoil, which are the species which the wood white butterfly lays its eggs on, and the caterpillars of that butterfly eats the leaves of those plants, showing that the grassland would be suitable.
Thank you. So, Inspector, we then move on to topic C, and again, dealing with it in the same order, looking at impact on habitats. And I'd like you to first look at appeal site A And really, the difference between you on this in respect of your position and the appellant position relates to the not whether or not there was woodland on site, because you've dealt with that, but it's just the quantity of it. And I'd just like you to assess or to help the inspector with what you say about that. We can see that within the CD 2A.6 ARBTEC report, they say that development has resulted in the loss of 0.54 hectares of woodland. So what's your position in respect of that, if it differs?
I measured the woodland lost as 0.09 hectares of woodland, so substantially larger than the ARBTEC measurement.
And is that the calculation that the inspector sees in your paragraph 5.8?
Yes, it is.
And in terms of that habitat then, is that the habitat that would have been providing, or would that have provided habitat for species as well on site?
Yes, it would. Yeah.
And then what about the impact insofar as the watercourse that you've discussed? Is that another impact that you think the inspector should take into account?
ARBTEC didn't notice there had been a watercourse there, but in my professional opinion, the loss of that watercourse is a significant ecological harm and breaches policy NE2.
And you've taken the inspector to your pages 6 and 7 where you summarise the policy. So I won't ask you to go back to that, but I'll ask you to move on to appeal site B then, and also C and D. So in respect of those appeal sites, the report simply says the same page number as before, 2B.11. The proposed. Yeah, going back to the Darwin one, Inspector. Yeah, 2B.11. So it's the one that's said to be in respect of plot 5, which corresponds to appeal site B. And it's the next paragraph along, really, in respect of the impact on habitat. So we looked at 1.2, and then we go to 1.3. And what's the consequence of not having assessed the pre-development position in respect of 1.3 then in respect of that report, if any?
In that paragraph 1.3, the author says the development would result in the loss of hard standing and improved grassland. And of course, that's the post-development being used as baseline. So in reality, the development caused the loss of lowland mixed deciduous woodland, habitat of principal importance, the watercourse and the unmanaged long grassland with scattered scrub.
So just go through those again.
Sorry.
What was lost on those sites?
So on B, C, and D, the woodland habitat of principal importance was lost. The watercourse was lost, and the third habitat lost was the open grassland with scattered scrub.
Thank you.
And you've indicated that the same policy considerations apply in respect of B, C and D, so I won't ask you to reiterate that, but instead, Inspector, move it on to the next topic, which I've called D, impact on species. And again, can I ask you to address that in the way that we have done with the habitats by going into, for appeal site A, the CD 2A.6 ARBTEC document, where we'd looked at those species when we looked at the baseline, and just helping us with your response to those in terms of what's the consequence then of the impact.
So with all the various species we discussed as being potentially present at baseline, the development on appeal site A would have resulted in the loss of almost all of them. The slight exception might be that a couple of trees were retained, which might support some of the breeding bird interest. So it could have resulted in the destruction of the protected plant species, which architect says were present, habitat for nesting birds, and destruction of birds' nest during woodland felling, killing of reptiles and loss of reptile habitat, loss of invertebrates, the loss of bat roosts, and bats, of course, are European protected species, a loss of foraging and commuting habitat for bats. The use of lighting could deter bats and could have resulted in the destruction of badger sites.
I think you said a couple of trees, or some trees may
I-
have remained or have remained.
I think there were 2 trees remaining.
Right, and does that provide any useful habitat at all for any species?
The 2 trees could well provide some nesting habitat for breeding birds.
Right. Thank you.
All right, and you've addressed the position in respect of newts and the wood white butterfly in relation to the baseline when you identified those. But just to confirm, what's the position in respect of those items as well?
If there had been great crested newts on appeal site A at the time of the construction, then they very likely to have been crushed by the laying of hardcore. The wood white butterfly no longer receives the benefit of the shelter of the woodland on site A if it were present on the adjacent land.
And then moving on to appeal B and C to D then, Inspector, for your note, we've got at the same EIA, the CD2B.11 document, it's paragraph 6.3, where it says temporary loss of these habitats will have a negligible impact on protected species. So, yeah, CD2B.11. And paragraph 6.3 is where it says that. So what's the situation, and identical comments, Inspector, in respect of those other. So you're always going to be looking at, well, what does the situation pertain in respect of C and D? And each time I give you a reference, there's an identical reference in respect of C and D. But for your notes, so you've got them all in one place. The C document is at CD2C8. And the D document is CD2D.11. So, and in respect of those appeal sites, then what's your conclusion on the impacts then in respect of all of the species that would have been present?
The ecological impact assessments that have just been referred to, sir, say for each of the appeal sites that there'd be a negligible impact on protected species, which in my mind is incorrect, because again they're using the post-development situation as their baseline. So in reality, with the baseline of the site as undeveloped, the development would have had a direct impact of the killing and loss of habitat for wood white butterfly if it had been there, and also for the reptiles, breeding birds, great crested newt had they been there, bat roosts in the woodland, bat foraging ability, hedgehogs, other invertebrates.
And in respect of the wood white butterfly, I just want you to help us with the references so we can find them in the documents that you put in your in your proof and your appendices. So in respect of really when the inspector's looking at impact on species and significance of that, in respect of the wood white butterfly, can you help him by going to your Appendix 10 and the fourth page of Appendix 10? And just reminding everyone that your proof is at CD 8A.3 if we're looking electronically. Appendix 10, and it's been Appendix 10, yeah, and it's page 4 of Appendix 10, and you should see when you get there, Inspector, some headings on that page: biodiversity and endangered species, and it's really the first paragraph under endangered species, wood white butterfly. I'd just like you to help the Inspector with the significance of that, please.
Mr. Herman, who owns and lives at Thatched House Farms, said that Thatched House Farms land adjacent to the site is host to the endangered wood white butterfly, one of the UK's rarest and most threatened species. It's reasonable to assume that the proposed site would also have provided such habitat prior to the depositing of hardcore.
And we can see also, if you turn to your appendix number 11, so next appendix along, that's got internal page numbering. And if we turn to page 22 of that internal page numbering in appendix 11, we've got an appendix there. And I just want you to help us with what this says, if anything, about wood white butterfly.
This appendix is the report of a recent wood white butterfly project. And that page 22, appendix 11, lists the sites in that project where new habitat was created for wood white butterfly to colonize, thus expanding its range and population size. So there's a lot of different sites listed, but the very first site listed on that table is Thatched House Farm, where it shows 55 square meters of new wood white butterfly was created.
And while we're in that document, Inspector, if you turn back to internal page 10, you can see there we've got the dot indicating where Thatched House Farm is within the figure 2. And we can see some words underneath that in the paragraph underneath figure 2. And for the purpose of the Inspector in this appeal, could you just explain or remind us of the significance of those words, please, Mr. Sibbott?
Yes, so on that figure 2, Thatched House Farm is the dot on the top boundary of the site to the right of centre. Dunsfold Farm is written on the map, and Thatched House Farm is up and left a bit from the words Dunsfold Farm, to orientate you, sir.
Is the witness saying that's the presence of a woodland white butterfly, or is it saying it's the creation of a habitat?
The map is showing areas of created habitat. So the words beneath that figure says, with the increase in habitat outside the main Chiddingfold forest colony, wood white butterflies have been recorded in outlying areas, including the churchyard at Chiddingfold and Grayswood House. This indicates that if suitable habitat is created and monitored, the wood white will start to colonize new areas.
And then finally, Inspector, just to bring us up to date on all the documents, you've got at Appendix 12, you've got the guidance for selection of sites of nature conservation importance in Surrey. In respect of that guidance, we can find some criteria on page 57 under butterflies. And if you can just 57, Inspector, of that document. So it's right towards the end. In fact, it's the last page in Appendix 12. And again, can you just help us in respect of what that criteria is saying in respect of the list A habitat specialists and the significance of them in the justification.
This is setting the criteria for the site of interest for nature conservation county-wide designation. So criteria B is sites supporting a butterfly species within list A in table 7, and then table 7 includes the 4th species down, the wood white butterfly. So basically it's saying that if one has the wood white present on site, it qualifies to be designated as a site of importance for nature conservation.
Now, during the last session of the inquiry, there was a blown up version of one of the maps in Appendix 11 that was passed up. I'm not sure if it was given an inquiry document number or not, but do you recall that map?
I recall seeing it, though I hadn't had a copy.
Okay, so it was a blown up. I think it may have been provided by Mr. Cottle. It was a blown up representation of the one of the maps in Appendix 11, I believe. Is that one that you were wanting to be added in as a core document, Stephen, or?
No, that showed the position of Thatched House Farm
Right.
correlating with that dot that we've just been taken to.
So do we
As a
need to go to that? That document? Do you want it in there as a core document or not?
Well, no, the listing of Thatched House Farm is a project, subject to the project for creating new habitats for white woodland butterfly. That's
Okay.
all.
Well,
That's all that we
I'm
know.
contented that's okay. Well, so we don't need to go to that.
It shows that that dot is Thatched House Farm,
All right.
which is listed in the back of the document as Thatched House Farm.
So let's go to Inspector topic E then, the final topic that I've identified to wrap up various points. And this is really just dealing with any suggested mitigation, compensation, conditions points. And I'd like you to take the same approach as with the habitats and the impacts on those and the species and impacts of those. So to deal with Appeal A first, and in respect of the CD2A.6, the ARBTEC report dealing with A, we've got a list of compensation and mitigation strategies which the ARBTEC report lists in those pages that we've looked at previously within that report. I don't necessarily ask you to go to them again, save where you want to. But what I would like you to do is to help the inspector with what surveys he's had in relation to the various species that are identified there, and what you say about those surveys, the adequacy or otherwise of them.
There have been the surveys of the great crested newts we discussed earlier, which failed to include survey of the pond.
Sorry, Mr. Civic, could you give the date of those surveys and who made them?
Yes. We recently discussed the newt surveys in they're in CD 2A.8, and the surveys were undertaken in 2024.
Were those the 25th of June 2024? The eDNA surveys.
Sorry. Am I allowed to answer questions at this stage?
Well, I mean, so I mean, you shouldn't really. I mean, but I mean, I can say to Alan that yeah, it's the same document we went to, the CD2A.8. So
just trying to clarify.
If you're looking at the second page of that where it says 25th of June, it's that document, Alan.
Yep. Thank you.
Yeah. So you've said that you've made your comment in respect of that survey.
Previously.
What about the other surveys that have been done, if any?
There have been no other surveys done to a good standard of any species. If I can talk about badgers and botanical survey. So if we go to the ARBTEC appraisal and look at its recommendations.
So we're going to the pages that follow on from 17, and the surveys will be on page 24, Inspector. And so, Mr. Sibbett, in terms of what we see in respect of badgers, what are your comments there?
So in respect of badgers, this is on page 24, so of the ARPTEC report. It recommends badger surveys of the adjacent woodland and to confirm if badgers are present in the woodland that's left. And will comprise the deployment of wildlife cameras over a period of 3 to 4 weeks. But then if we turn to the ARPTEC, turn to the Darwin Ecology letter on CD2A.7. This is the January 2024 letter.
It is the one with the photos.
It is,
sir.
yeah.
Whereabouts?
So on the second page, at the bottom, there's a heading, Badger Walkover. Badger Walkover subheading, yeah. So the surveyors searched the surrounding woodland and any areas within 30 metres of the development site for signs of badger presence, such as snuffle holes, latrines, hares, scat or set entrances. And mammal paths were also searched for, with the surveyors checking the paths and surrounding vegetation for evidence of badger activity. Now, that's not the 3 to 5 weeks of camera survey which ARPTEC recommended. It's substantially less than that. Just one site visit, walking over.
And
did you say 3 to 5?
Yes, which is what which is what ARPTEC recommended on their page
24.
24. Sorry, 3 to 4 weeks. Sorry, sir, not 3 to 5. 3 to 4 weeks.
And whilst we're in that same document, the CD2A.7 document, we can see there that we just looked at page 2, but if we look at page 4, we've got something called a habitat walkover. And I just want you to help us with how that compares to what ARPTEC suggested should be done in respect of a botanical exercise.
So the habitat walkover on page 4 of CD2A.7 that we're in consists of a description of habitats such as woodland, fields, scrub, neutral grassland, scattered trees, a pastoral field, that level of detail. What was recommended by ARPTEC on CD2A.6 on their page 20 what was a botanical walkover of the adjacent woodland to try and establish a baseline condition for the woodland which was lost. So in my mind, a botanical survey includes recording and writing down the names of the particular plants, the names of the trees in the woodland, the names of the shrubs, and the names of the ground flora. And none of that was provided in the habitat walkover.
So are you expecting a botanical walkover to be more detailed than a habitat walkover?
Yes, I was expecting much more detail on the botany of that service, of that survey, giving a lot more detail on the plant species which were there, which is what botany means.
Now, in terms of reptiles, within the CD 8.6 document, it says that the habitat is gone, but it's unlikely they would have been impacted. So I just wanted you to have a comment on that in the context of whether or not there have been any surveys or anything to justify that conclusion.
Yeah, but back in the UpTech report, on page 22, the top row of the table is a continuation of reptiles from the previous page. So in the left-hand column on reptiles, the last sentence says, the woodland adjacent to the southwest and formerly on site may have provided reptiles with refuge opportunities, but the site in its current state has negligible value. Then immediately to the right of that, the last sentence, it is considered unlikely that reptiles would have been impacted by the proposed development. And I find that quite remarkable, that it says that the site may have provided refuge opportunities, but actually none were harmed.
So in respect of this point then, surveys, that you've referred to the totality of it. So can the inspector take it that there haven't been any surveys done in respect of roosting or foraging bats, hedgehogs, birds or invertebrates then?
That's correct. There haven't been any surveys in relation to those species.
And in terms of the consequence of that, can I ask you to help the inspector with what that means when he's coming to look at whether or not, leaving aside whether or not the development plan policies provide for compensation under the policies you've referred to, if it's suggested that the habitat and the species loss can be compensated for, what's the consequence of what you've just said to the inspector for that issue?
Because those surveys weren't carried out, sir, one can't design mitigation or compensation because we don't know exactly what was lost and can't design compensation to replace losses because it's all quite unknown what to design.
And can I ask you to go to one of the cases that you've referred to in your appendix 5, which touches on this point? So appendix 5, inspector, in that same volume of appendices to the proof of evidence. And then when you're there, inspector, I'll be asking you to look at the ecology section on page 4. Appeal decision, yes, by Inspector Young. And on page 4 of the decision, we can see there's an ecology section. It's paragraphs 21 and 22, really, that I want to ask the witness about. And in particular, I'll ask you to go to the circular, which you've also provided in your appendices, which the inspector is discussing there. But what's the importance of these paragraphs to this issue in your evidence, Mr. Sibbett?
So the paragraphs in the appeal decision confirms in paragraph 21 that guidance on the conservation of protected species is in circular 06/2005. And at paragraph 99, the circular advises that the presence or otherwise of protected species and the extent to which they might be affected by the proposed development must be established before planning permission is granted.
And what about what it says in paragraph 22 and the relevance of the way the inspector treats there, in particular the way he discusses the precautionary approach?
So in paragraph 22, the inspector says, although an ecological report was submitted with the application, it did not include surveys to establish the presence of protected species. And bearing in mind the advice in the circular, and notwithstanding it, it might well be possible to mitigate the impact on protected species should they be present without the requisite surveys it is not possible to ascertain the effect of the development on a protected species, and a precautionary approach should be adopted.
And I don't ask you to turn it up, but the inspector there, and for your note, Inspector, we've got the circular in Appendix 2 of Mr. Sibbitt's evidence, and paragraph 99 is on page 33 of that, which says what the Inspector Young has quoted there. It's essential that the presence or otherwise of protected species and the extent that they may be affected by the proposed development is established before planning permission is granted. Otherwise, all relevant material considerations may not have been addressed in making the decision. In respect of the other matters that Mr. Woods talks about, can I ask you to address in particular one of the things he says within his paragraphs 9.17 to 21 in respect of the wood white butterfly, and he suggests a condition securing a 1 metre wide strip of grassland in respect of that. Now, it's something that you've dealt with in your rebuttal evidence, so you can be relatively brief about it. But what do you say in summary about that idea as something being effective to provide compensation?
A 1 metre strip of grassland around the periphery of the sites is going to be very narrow. It's going to be very shaded by hedging or fencing, and it's grossly inadequate to compensate for the losses of habitat. A 1 metre shady strip of grassland would inevitably be species poor due to the shading and edge effects, and yeah, certainly wouldn't be anywhere near the quality of habitats which were lost.
And then for completeness, I suppose Mr. Woods proposes a condition in his proof in respect of site B within those same paragraphs. Can I just have a comment from you in respect of that condition, please? And in particular, given the context of what you said about surveys, etc.
I think the condition is unachievable because it's not informed by survey, and the condition can't be implemented in a way it can demonstrate that it can provide adequate compensation or mitigation. That's for Appeal A. For Appeal B, the ecological impact assessment, which is the Darwin ecology one we looked at recently, contained no habitat mitigation because it used the post-development baseline, but the post-development hard standing as the baseline. So it's unclear how a condition could provide mitigation or enhancement.
And then could you just take us through, as the final topic then, the policies that we've got in the development plan that we went to originally in your paragraphs, pages 7 and 8. And you've told us that those paragraphs apply to each of the appeal sites A to D. And we can see there on page 7, we begin with policy NE1. And so can you just help us then at this point, having said what you've said about mitigation stroke compensation and all of the impacts, what do you say, where does that leave the inspector in respect of policy?
In respect of policy, sir, I think it leaves you with policy NE1, priority habitats, brackets, local designations. Development will not be permitted unless it's necessary for appropriate on-site management measures or can demonstrate no adverse impact to the integrity of the nature conservation interest. So that part of NE1 applies to the deciduous woodland priority habitat.
What about more generally in respect of NE1A then as well?
So NE1A, development will be permitted provided that it retains, protects and enhances features of biodiversity and geological interest and ensures appropriate management of those features. So the protected species, which we've discussed, are features of biodiversity interest which are covered by NE1A.
And has that in your evidence, has that happened or not, NE1A?
It certainly hasn't happened.
And what about NE1B then in terms of the sequence of actions that it describes?
NE1B says ensure any impacts are avoided or if unavoidable are appropriately mitigated. So that there's been no avoidance whatsoever and that there's been no appropriate mitigation offered and none is realistically possible within the sites.
And that policy doesn't provide for compensation, but insofar as what you've described in respect of compensation for the loss, what's the situation there in relation to that aspect of it?
The provision of compensation, because of the scale of the habitats lost, isn't possible within each of the appeal sites.
And what about NE2 then, where we come on to the blue infrastructure, and in particular in relation to the watercourse? You drew the inspector's attention to the sentence which says that there will be buffer zones to all watercourses of 8 metres for main rivers and 5 metres for ordinary watercourses. So you explained that we're 5 metres for ordinary watercourses. What's the consequence for policy in respect of sites A to D for the inspector on that issue then?
The consequence for each of the 4 appeal sites is that no undeveloped buffer of 5 metres from the ditch has been retained, and so each of the appeal sites fail policy NE2.
And then just finally, for completeness and to make sure we've covered everything, as a last question, in respect of the framework in paragraph 193, with which obviously the inspector will have in mind whether there's been significant harm to biodiversity in the test that's laid out there, what do you say about that particular test and the appeal sites?
In my proof on page 8, it's paragraph 186 from the 2023 version of the framework. So paragraph 193 of the new framework is exactly the same wording, just the paragraph numbering has changed.
Yep.
And it says, if significant harm to biodiversity resulting from a development cannot be avoided through locating on an alternative site with less harmful impacts, adequately mitigated, or as a last resort compensated for, then planning permission should be refused. And each of the 4 appeals haven't avoided harm. They're not able to adequately mitigate, and they're not able to adequately compensate. So the appeal should be dismissed.
And what is your professional view, given what you said in your evidence, as an experienced ecologist, as to whether or not the harm that the inspector is considering on these appeals is significant harm to biodiversity?
The harm is significant because of loss of woodland habitat of principal importance, because of the watercourse which has its own policy, and because protected species are very important in law and in planning policy. So all the harms are significant.
Now, Inspector, I've managed to shave about 15 minutes off my time estimate there, so hopefully I've pleased Mr. Cottle in that respect. And that's all the questions that I propose to ask, subject to anything.
Yeah.
Yourself, Inspector, of course.
Thanks, Mr. Lintott. Just one thing I'd like you to help me with, if you can, Mr. Sibbott, at this stage. Policy NE1, where you quote the policy in your proof, page page 7, and you've highlighted the part about local designations or the priority habitats. Is the extent of that local designation available on a plan? I don't know what, I may well have it, but I just want to check.
Yeah.
Sorry, I've got the microphone again, sir. On figure 1 of my proof, it shows the appeal site and the location of priority habitat woodland, which was taken from the government's magic map, which shows the location of the priority woodland.
So that's the dark green on figure 1.
The dark green, sir, yeah.
And that's consistent with what's NE13 says. That's what's meant.
I believe so, sir, yes.
Right, okay.
And if you turn the page to figure 02, it just shows the same woodland at a slightly larger scale. So the dark well, the green color is the woodland,
Right,
which
okay.
has been lost, and then the very dark green is the retained priority woodland.
Yes. Okay, thanks, Mr. Simmons. Before I decide what we're going to do next, let me just get an indication of questions from the advocates. Mr. Masters, how long do you think in cross-examination?
I think I'm going to go first.
Oh, right,
I know, we had.
You swapped around, but you didn't tell me.
We did indicate we would do our first day a long time ago, and we just having a discussion.
Okay, well, so Mr. Cottle's first. How long do you think, Mr. Cottle?
A good hour.
Yeah. And Mr. Masters? Okay. Of course, yes, I would. That's what I would expect you not to do. Right. Well, if you've got, based on those estimates, I'm inclined to take the lunch adjournment now and then run through after that. Well, I'm glad you're on the same wavelength, Mr. Masters. That's good. So we'll adjourn now.
Inspector, given that we're talking about timing,
yes,
Mr. Masters has helpfully indicated who he's going to be calling tomorrow.
Yes,
and we've got that from Mr. Cottle as well.
Yes,
I'm at a stage where I've obviously looked through the information that's provided, and so I can say that I think my 30 minutes for each of the applicants is going to be longer than I will actually be. Maybe I've got very little for them. So I would imagine that although we're not making the progress perhaps that we would have wanted, I'm sure we're going to get through on the basis of the estimates that we've got the appellant's evidence tomorrow.
Could I just say that, as I understand I haven't got proofs.
That's right. Yeah, it doesn't look like we are at the moment, but I think that's right. When you take Mr. Rowe out of the equation, things as well. Yeah, absolutely. Thank you, Inspector.
So could I ask, am I in Perda over lunch break? Hmm.